May I please the Lord's mail?
Yes.
No, item number 5, today's list, my lord. Motion. So I expected to get some
Item 5 motion.
motion, my lord. I
There's no
expected to get
motion.
some documents, my lord. So I need 2 weeks time, my lord.
Which motion? Which court?
This court.
Item 5 motion? There is no item 5 motion. I think you are mistaken.
Just a minute. Single.
We are not on single.
140, my lord.
It happens at times for a busy lawyer.
Extremely sorry.
Yes.
I have filed an additional affidavit in item number 24. It needs to be read that you take the matter.
Bring it.
Item number 20.
24.
Yes,
Bring it. You want to have it today?
yes, Lord.
Lordship, I beg to mention item number 18.
Yes.
May the matter be passed over for the day,
18 is a 18 matter.
my lord.
We are not passing over 18 matter.
My lord, it is because senior counsel has another part-heard matter going on, and due to some personal difficulties, its passover has been sought for, my lord.
This is the 18
Anything-
matter.
Any
18 in a criminal appeal. He is behind the bars for 7 years, 9 months, 29 days.
Life imprisonment, life imprisonment.
my lord.
Okay, when can you do? Thursday?
My lord, Friday, my lord.
Yes, madam. A request for adjournment has been made on behalf of the appellant. Full stop. However, noting that the appeal is pending since the year 2018, though an accommodation is granted, the same is directed to be listed for hearing on Friday.
My
Please
lord.
give the date.
My lord. Obliged, my lord.
Miss B. Bhuya, learned APP, is present.
Item 1. Mistakes.
Yes,
Right, this is your lordship. Lordship, as per the instructions of my senior, he has been allotted this matter recently, so he prays for a week's time for preparation of the same.
what is the matter, Mr. Bunik?
My lord, interestingly, there were 2 AGMs for a particular cooperative society.
It's come for the first time.
No. It's only for the finishing part. All pleadings are served.
Okay, your senior is Talukdar.
It has been allotted to Mr. G. Botama.
G board law. Well, last time Mr. Talukdar had appeared.
Yes.
Okay. When can he get the instructions?
Week's time.
So next Monday?
Right.
Next Monday. While Sri S. Bonik, learned counsel for the appellant is present, comma, a prayer for adjournment has been sought for on behalf of Sri G. Borderler, learned standing counsel, Cooperation Department. Para? Considering the above, matter is adjourned to be listed on Monday next.
Item 2.
Item 2. Criminal appeal. Record the None appears for the appellant on call. Sri Kaushik, the learned APP is however present again. Though this appeal has been listed under the admission column, comma, records reveal that the same was admitted by the order dated 2/6/2025, and records were also and TCR were also called for. Full stop. We have been informed that the TCR has been received. Para? Office is directed to prepare the paper book and list the appeal for hearing immediately thereafter. No? Is there any private respondent?
I don't think so.
Under what? NDPS, okay, no private response.
NDPS, madam. NDPS. They have,
Item number 3,
no, in item number 2, they have made party the SI.
doesn't matter, let us see everything. Because in POCSO matters, their presence should become mandatory.
Yes, madam.
Now, in NDPS, that may not be mandatory. Yes, next, item number 3. POCSO matter.
11B. This unjust enrichment is also there. That is also not satisfied. The tribunal said that before considering this aspect, the department is given an opportunity to hear to consider this aspect of the matter. Lordship 1 and C, in my opinion, Lordship, these are the substantial condition of law to be considered by your Lordship.
EC is education says.
Yes, Lordship.
What is HEC?
High secondary Lordship says.
Huh?
High secondary says. Secondary and high secondary says.
So their claim was not held to be time barred. You say if it is not
Ye-
claimed within a period of a
1
year,
then it is
it becomes time barred.
time part.
And the learned tribunal, appellate tribunal
Lordship
had held
held
that
that,
since the payment was made by mistake
so
of law,
yes.
so that bar would not apply.
Not applicable.
Uh,
Lordship, in the meantime, Lordship,
So what is the substantial question of law?
Lordship, section 11B will be applicable in our
Let us see 11B.
Lordship.
11B of the Central Excise Act.
It's probably page 50.
Page
Page probably 40.
11B.
Yes, sir. Merit.
Please read.
Claim of refund of duty of interest, if any, paid on such duty. Any person claiming refund of any duty of excise or interest, if any paid on such duty, may make an application for refund of such duty and interest and paid on such duty to the Assistant Commissioner, Central Excise or Deputy Commissioner, Central Excise before expiry of 1 year from the relevant date, in such form as manner as may be prescribed by the application, shall be accompanied by such documentary or other evidence, including documentary referred to in section 12A, as the application may furnish, establish that amount of duty, if any, paid on such duty or relation to which such refund is claimed, was collected from or paid by him, and incident of such duty and interest, if paid, has not been passed by on him to any other person. But initially that the executing authority rejected the claim of the petitioner on the ground of delay, as well as they failed to submit that they have passed on the duty to some other person. Lordship, Honorable Tribunal, in page 104 of my appeal.
What about the proviso second
Lordship,
proviso, if
provided that the
there
time
is
limit
also a window
shall-
provided.
shall not apply where duty of interest of any has been paid under protest.
So if it is under protest, there is a window
Yes,
left
then-
open.
Yes, that is open.
Now, if that means this period is
Flexible.
flexible depending on the facts and
Facts and
circumstances.
circumstances.
So the tribunal had come to a finding
Tribunal
that the
seem to
payment
finding
was
that
made on a mistaken.
so limitation act under section 11B is not applicable. And regarding unjust enrichment, the tribunal held that because they submitted a certificate of the chartered accountant, the department should have given a opportunity to them before deciding the issue. What's page 104? Part of the order.
11B does not contain any power to,
No, Lordship,
On
my
the-
humble, and Lordship, recently, the full bench of Chennai, CSET held that on the basis of Supreme Court judgment rendered in Mohabbatlal, that is a constitutional bench, held that that was relied on, and Lordship, this is a judgment,
what has been held?
that limitation period is mandatory.
Mandatory. Just a minute. What is seized?
On the basis of whether it can be accepted on the basis of CSR.
Question of law, what we can do. Question of law.
Not be used.
How is C a substantial question of law?
Lordship, because Lordship,
question of
tribunal has
fact.
right, Section
It has to be not
11B.
only a question of law, it has to be substantial question of law, substantial to the issue involved.
Yes, Lordship, here. in my-
A and B is the one.
A1 is.
A and B, we can and we are just thinking whether that can be constituted as a substantial question of law.
Lordship.
We can admit this on A or B. Okay.
B, Lordship will do.
B.
Yes, C also, because Lordship tribunal specifically held that.
How is
That-
law in ignoring the statutory presumption of hundreds?
Whether it can be allowed on the, without substantive evidence. That can also perhaps.
Lordship, A or B one, anyone will do that.
Third, three, SC Kyle. Learned. Your senior standing counsel
Lordship,
of the CGST,
Lordship,
who has preferred this appeal under section 35G of the Central Excise Act 1944 against the final order so and so and so. The appeal is admitted on the following substantial questions of law. Huh? B or C. Having C also, let us see B and C. Okay. Issue notice upon the respondent. Let steps be taken for service of notice by usual manner. Steps within 2 working days. List after 6 weeks. List we'll give a date. Today is 16th. List on 20th of no, today is 16th. List on 18th of March
Lordship.
or 23rd of March.
Lordship,
Along with the
request
report.
of the impugn order, Lordship.
See what
Lordship,
case?
because Lordship, the tribunal is insisting that we should refund the amount.
Where is the direction?
Lordship. They have come with an contempt application that is considered by the Minute Tribunal also.
Heard PSC Kyle Learned, senior standing counsel for the applicant appellant who has filed this application for stay of the final order dated so and so. The connected appeal preferred under section 35G of the Central Excise Act 1944 has been admitted today. Para, let notice be issued, returnable on same date, huh? Yeah, go to this. Let steps be taken for service of notice upon the respondent by usual manner. Para. Three, I, as the attending counsel has informed that in the meantime, an application for initiating contempt proceeding has been filed, para, considering the above, comma, till the returnable date, the impugned order dated so and so shall remain suspended.
Much obliged.
We have kept it alive.
Lordship, we'll take a step in both. Much obliged.
Maybe apology. My lord, I'm sorry, my lord, item number 2, my lord.
Yes,
My lord, lordship, our appearance may be recorded, my lord. I was.
TCR has come, we have
Yes, my lord.
none appears to Katiriba, huh? We cannot record your presence here, not present, but
Yes, my lord.
we'll omit the non-appearance part, okay?
My lord, if the state may be fixed,
Immediately, we say immediately on preparation of the paper book.
my lord, oblige, my lord.
You or your colleagues should be there, Mr. Murray.
Yes, my lord.
Some of your colleagues should be there when the
My
matter is
lord,
called upon.
actually, due to traffic jam, my lord.
Understood, but there are 4 of you. Somebody
Yes.
should be there, or you can call some of your friends in the bar. It looks very bad when the
Yes.
matter is called upon.
I'm sorry, my lord.
22 year appeal has already been admitted, your lordship, day before yesterday. Only thing, your lordship, 2-year conviction. The for passing and suspension of the sentence, your lordship, the honorable court wanted to see the order by which, your lordship, I am allowed to remain in bail, your lordship, on bail, your lordship.
Order allowed to remain on bail. They were allowed to remain on bail in the next day. 2 years sentence.
Kasi with that, like, the rest of the accused were, your lordship, punishment is for life, your lordship.
Okay. Okay.
Rest have preferred separate appeals.
They have preferred separate.
The sentences are different.
Life imprisonment, and this man is 2 years old.
As brought up, counsel for the applicant and RR Poshik learned additional paper. Instant application has been filed seeking suspension of sentence passed by the learned additional session judge FTC Sivasagar in sessions case number 41 SS 2020, whereby the appellant herein was convicted under section 354A1I IPC and sentenced to undergo rigorous imprisonment for 2 years and pay a fine of rupees 3,000 in default, along with default clause. The appeal has already been admitted and the present interlocutory application has been filed for suspension of sentence and bail. So the learned counsel has placed before the court today an order dated 12/1/2026 passed by the learned convicting court, allowing the convict appellant to remain on previous bail till the next date. Stop. Considering the nature of sentence and the fact that the convict appellant is presently on bail in exercise of powers under section 530 BNSS. Check. It is directed that execution of the order of sentence dated so and so passed by the learned additional session judge FTC Sivasagar in sessions case number 40 shall remain suspended till the disposal of this appeal. It is further directed that you'll submit fresh bail.
Lords.
Stop. It is further directed that till the disposal of the appeal, the appellant is hereby allowed to go on bail of rupees 30,000 with one surety of the like amount to the satisfaction of the learned traveler. The applicant shall submit fresh bail bonds and subject to the condition that he shall be available to receive the appellate judgment, and he shall not in any manner harass or intimidate or harm any of the witnesses who have deposed during the trial.
Lords.
I stands allowed and disposed of on the force.
Deeply obliged.
430.
Deeply obliged.
Four and five.
Four and five are
Hello,
order.
I received, I did the paper book, my lord.
NDPS taking.
Oh, my God.
You are in which case, Mr. Chaudhary?
I am 4, my lord, and I am going to appear on 5, my lord. But 5, we are not receiving the Okalam number till.
You are the new set of counsel.
That's my lord.
Okay. But 5 you will also appear.
I shall appear, my lord.
Okay, doesn't matter. The paper book has been prepared.
Appear, my lord.
Can-
It's for hearing, my lord.
5 we have received, my lord.
Same paper book.
Same paper book, my lord. There are 2 accused person, my lord.
Same judgment.
That's fine.
So we hear the matter? Yes,
For hearing.
you
Or
can hear it now. Paper book is there.
that's
No, Mr. Chaudhary is ready with the matter.
Photo paper, one.
He smiles, yes, see? He smiles,
Point
yes.
is that, my lord, one point is that the age should be proved beyond all reasonable doubt. After age has been proved, my lord, preponderance probability will come. But,
NDPS.
huh? Oh, so. Sorry.
NDPS.
Okay, please. My lord, here
You are not
you
prepared, Mr. Chaudhary.
can prepare, my lord. This
You
is
have
a
prepared some
NDPS
other case and making arguments
No,
in some
sorry,
other
sorry,
case.
there is a, my lord. What happened, my lord, in the instant case, section 52, 42 was
Where is
not,
the question of age in an NDPS matter?
no, my lord. Sorry, my lord. I am preparing another case to the board.
So you have to come prepared.
Yes,
We are just checking you.
yes, ma'am. But my lord, one is the.
You are trying to confuse the court
Yes, ma'am.
and confuse the PP also.
Yes, ma'am.
21C.
How many witnesses?
There are, my lord, 4 witnesses, my lord.
8.
8 witnesses. 8 witnesses.
You have reduced the witnesses by half.
Yes, my lord. Page 80, my lord.
What is the contraband?
Contraband is a heroin, my lord. 270 gram, my lord. Heroin. 278 gram, my lord.
Okay. Yes, we have it for hearing.
Yes, my lord.
Heard Sri NNB Chaudhary, learned counsel for the appellant, who has also submitted that he would also appear for the appellant in Criminal Appeal 114 of 2023. Full stop. Also heard Sri R. Kaushik, learned additional PP Assam. Full stop. This court has been informed that the paper book has been prepared. Full stop. Para, list for hearing in its turn.
Six and 7, lordship, paper book is ready, my lord. Can I be fixed for hearing?
My pleasure.
Paper book ready?
Ready. I have
Okay,
received.
we'll have it on its What is your name?
K Islam Ali.
A.
K
K
Islam.
Islam.
The service is also complete.
Okay. And there is a legal aid counsel.
Yes, my learned friend is appearing.
Madam Bodler, you are for the respond number 2. Okay, same order. Huh?
I'm appearing in the item number 7, madam.
7, huh?
Yes, ma'am.
They're connected.
Yes, ma'am.
You are Gayan.
Yes, ma'am.
Okay. K Islam for criminal appeal bottom to her 293. A Gayan, criminal appeal 89/2023. B here, APP. And PB Bodler learned legal aid counsel. Baki khini ake.
Oh, that is.
Huh? Paper book is for hearing in staff. Okay. Doesn't matter, you're, where appellant side?
Where did it pass? R2 to class.
No, we have correctly laid.
Much obliged.
I'm obliged.
7 it is okay.
7 not Gundagol here. 7 is Gundagol.
No, it's listed both sides.
Huh?
It was- It's mentioned both sides.
My lord, if possible, date may be frequent.
We're not fixing a date. See, criminal appeals are in chronological order.
I have been filed for bail, my lord. Thank you.
No, we'll have for hearing. The other matter, we cannot just fix a date. It has to come up in chronological order. Matter of which year? 24. We have criminal appeals of earlier years. Okay.
I'm obliged.
Item 8.
8 also paper book is ready, your lordship.
Who is for the petitioner? Appellant.
Appellant, check.
Same order will pass.
Lord.
Item number 8. Your name?
Ayush Chaudhary.
Ayu Chaudhary. Okay, Baki. Yes.
Book is ready.
Deep level.
Item 9.
May please, your lordship. Paper book is ready, your lordship. Maybe respect.
This person. Lordship, we did receive it.
Well, you'll be receive it in the meantime. Mr. Atreya, your name is not there?
No, I'm appealing on behalf of Mr. D.K. Bhattacharya.
Acha. Yeah, Atreya.
Yes.
Atreya on behalf of D.K. Bhattacharya and AEPP, huh? Vibhuya. See.
Obliged.
Item 10.
Item 10. Paper book has been received.
Not by.
But in the meantime, I'll go to them, huh? I'll go to Likhiba. As the BPP additional P also heard so and so, who has, however, informed that the paper book is yet to be served upon her. Registry to serve a copy of the paper book in the office of the public prosecutor or something. Or it the same, huh? What is your name?
Yes, Chaudhary. On behalf of Libora.
Item number?
10.
Your ES Chaudhary,
Yes, Chaudhary. On behalf of
Libora.
Libora.
And there is an amicus curiae, response number 2.
Mr. D.K. Boyto's name is shown.
Madam, are you appearing for him?
No, he is assistant.
Then who's there?
Mr. Boyto.
No, anybody for Mr. Buddha? Nobody is there. Okay, doesn't matter. It will be voided, huh? You have not received copy of the paper book, madam?
No,
Okay, same order. I'm not told.
I'm not sure whether paper book is prepared.
Yes, it's prepared.
It is there.
He's got a copy.
Sure.
Okay, same order, huh? Copy. Mr. Bora, paper book is there? Paper book prepared?
No, not prepared, Lordship. On the last occasion, on 6/6, TC was called for, but the list does not reflect that.
TCR, is it?
Is you not received as per the.
Otherwise, the objections from the state has been filed against the suspension of sentence.
Conviction under what section? Conviction under what section of law?
302 and 34.
Let the
It is based on a last seen and extrajudicial confession, Lordship, admittedly.
And sentence is what?
Life in prison.
We'll have the paper, TCR there. Where is the reporting?
The PCR has been forwarded
Has been
as
received
per the
to the-
office note. Doesn't forward on the
Yes.
question just.
Forwarding letter of 11/2/2026, recently,
Not yet received.
yes, okay. Heard 3 BP Bora, learned counsel for the appellant, also heard 3 RR Kaushik, learned additional PP, as well as Miss Som for the response number 2. Para. Office note reflects that office note dated 11/2/2026 reflects that a forwarding letter for transmission of the case records has been received from the learned court of the district of the session judge, Choraido, para, office to look into the same and tag the case records, TCR along with the case records and list the same after a week. Whereafter, appropriate orders for preparation of the paper book would be passed.
Lordship, I'll just, not today, Lordship, on the next date, I'll press on the IA, Lordship.
I is kept alive. On the next date, appropriate orders will be passed for preparation will not over. Appropriate.
I can clear.
But appropriate order, including the orders for preparation of paper book. Appropriate orders, including the orders for preparation of papers would be passed.
May I
Yes,
please,
item
my lord?
number?
Item 12, my lord.
Yes.
My lord, this is an IA for my lord, condition of delay, my lord. Delay of my lord only 35 days.
Okay, notice will have to go.
Notice has been served.
Notice has been served.
I am appearing, but I am sorry that I could not submit the power matter.
Okay.
I'll find the color number. by-
But are you objecting?
Only 35 days, my lord.
Otherwise, I have.
How
only
soon
one
can you,
matter,
how soon can you file the power?
my lord.
How soon can you file the power, the wakalatnama? At this stage? Okay, what is your name?
Lordship, MSS Nath.
Heard Miss S. Nath, learned counsel appearing on instruction of Dr.
P. Agarwal.
P. Agarwal, learned legal aid counsel for the applicant. Full stop. Para. This is an application under Section 5 of the Limitation Act 1963 for condonation of delay of 2090 days in preferring the appeal. Full stop. The appeal has been preferred against its judgment. It is so and so, passed in so and so. Para. Let notice be issued. Miss, yes, madam, your name? Name? Miss R. Saloy, learned counsel, assisting Miss B. Bhuya, the learned APP, accepts notice on behalf of the sole respondent. List after 4 weeks to enable filing of objection.
12-year sentence.
We give a date, madam.
Lordship.
List on today 16th. On 16th of March.
I'm deeply obliged, madam.
I did 17.
Wait, please, my lords. Lords, this matter appeal was filed, being aggrieved by
Item number
this
17.
17.
Yes, Mr. Chaudhary.
So, lordships, we were aggrieved by dismissal of our restitution of conjugal rights petition from the Dhubri family.
May it please, Your Lordship.
Yes, yes.
This is an appeal, my lord. Against the conviction, my lord, life imprisonment and my lord, fine of rupees 10,000, my lord. For
Paper book is there.
my lord, it is there, my lord. Eleven witnesses were examined by prosecution, my lord, during the period of trial, my lord. My. My lords will find the affair at case 4.
You are an amicus, Mr.
My
Da.
lord, my lord.
Mr. Kaushik will be appearing.
Yes, ma'am.
Conviction under
302, my lord, life imprisonment and fine of rupees 10,000, my lord. In default, my lord, 1 year of rigorous imprisonment. Lordships will find the affair at case 4, my lord.
Camp of bamboo.
My lord. May I read, my lord?
Just a moment. Yes, please read.
My lord, page 4, my lord. At the edge, my lord. Humble submission is that around 7:30 p.m. on 5/3/2015, one Chikoram Guala Elas Gui, Guala, son of so-and-so, a resident of village Telibosti, grievously injured his father-in-law Sri Sursing Gaur alias Bankot Gaur, son of so-and-so, by assaulting him on the head with a lathi made of stump of bamboo, and the injured person was brought to Dokmoka Primary Health Center, but later he died in Nagaon Hospital at around 1 a.m. on 6/3/2015 while undergoing treatment there. I therefore pray to the officer in charge of Dokmoka Police Station to take necessary action against the person who killed my brother, and oblige, my lord. This is the FIR, my lord.
The informant PW3,
My lord,
he is the brother of the deceased.
my lord. Elder brother of the deceased.
And the accused appellant is the
Son-in-law.
son-in-law of the
My lord.
deceased
Deceased,
person.
my lord.
You are interns or what? You have a seat. Don't sit, stand like that. Sit, there are seats vacant. Yes.
My lord, accordingly, my lord, charge was framed under section 302 of IPC, my lord. And during course of trial, my lord, 11 witnesses were examined by prosecution side, my lord.
11 numbers.
My lord. Now, lordship will find PW1 at page 9, my lord. He is basically hearsay, my lord.
Page 9.
9, my lord.
Who is he?
He happens to be Ashok Kumar Gupta, my lord.
No, not on the name, but who is he? He's a neighbor.
Neighbor, my lord, neighbor.
Yes.
I know the accused as well as the complainant. The incident took place on the day of Fakwa Holi in the year 2015. Around 8 p.m. that day, I was present at my home. At that time, hearing hue and cry, I arrived in front of the house of deceased and learnt that accused has assaulted the deceased. Thereafter, a 108 ambulance came and the deceased was taken to hospital. On the following day, I learnt that the deceased had died. Cross-examination, my lord, thereafter. The deceased used to consume liquor often. I did not see the deceased on the day of incident. This is his evidence, my lord.
He had heard. He had. Okay.
No primary knowledge, my
Okay.
lord.
Not relevant.
My lord. Page 10 is the daughter of the deceased, my lord. PW2, my lord. May I read, my lord?
Wife of the accused.
Wife of the accused. Reena Goala, my lord. The accused is my husband. The deceased was my father. The complainant is my uncle, elder brother of my father. On the day of incident, I was at my parents' home. My husband's house is situated near that of my parents' house. At the time of incident, the deceased came home after consuming liquor from outside and picked up a quarrel with the accused. A scuffle broke out between them. In the course of the fighting, when the accused pushed the deceased, his head got hit against a betel nut tree, as a result of which he sustained injury on the head, became unconscious and fell to the ground. I made a hue and cry, whereupon the villagers came and took my father to the hospital in a 108 ambulance. Police also came. My father died on that very night. Now, my lord, cross-examination, my lord.
Yes.
The deceased was a habitual drinker. At the time of the occurrence, the deceased was so inebriated that he could not even stand. At the time of the incident, the accused was also in an inebriated state.
Inebriate. Both were drunk,
My lord,
according to this.
my lord. May I submit one thing, my lord? Here, my lord, PW2, my lord, though she has not, my lord, supported the version of the FIR, my lord, she was not declared hostile by the prosecution side during her examination. And she also never mentions the name of PW3, my lord, the informant, to be present on the time of occurrence at the place of occurrence. Because in evidence, PW3 says, my lord, he has deposed that he is an eyewitness to the occurrence. Now, page 12, my lord, PW3, my lord, the informant, my lord. I know the informant as well as the accused in this case.
No, I know PW3 is the informant, no?
My lord,
Then I know the informant means,
my lord,
I know the deceased perhaps.
yeah, possibly, my lord. I know the informant as well as the accused in this case. I do not remember the date of the incident, but it took place 3 years ago. On the day of incident, Nam Kirtan was held in our village, and I returned home from there at about 6:30 p.m. After my arrival at home, my daughter-in-law, Hilmisia God, called me to have meal. As soon as I started eating, my younger brother, Sarsing God, deceased, called me. My house is situated near that of deceased. After finishing my meal, I went outside and saw the accused hitting on the wall of his house, which is situated near my house, with a big lathi. I told the accused that if he would hit the wall in that way, the wall would be damaged and he would have to repair the same himself. Then he left his house and started hitting the wall of his father-in-law Sarsing Gaur's house. As I tried to hold the lathi that was in the accused person's hands, the accused pushed me down. Just at that time, Sarsing Gaur came out of his house and the accused dealt a blow on his head with the lathi which was in his hand. The deceased fell on the ground instantly. His head got cracked and blood started oozing out. Then I called the VDP members and they came there immediately. After arrival of the VDP members, they informed the police. Meanwhile, the accused had fled from the place of occurrence and after committing the offense. After that, the VDP members started searching for the accused and caught him while he was hiding in a latrine of a villager's house. Thereafter, the VDP members kept the accused tied in a place near our house. After arrival of the police, the deceased was brought first to the police station and then to Dokmoka Hospital. As the injury sustained by the deceased was of grievous nature, the doctor of Dokmoka Hospital advised that the deceased should be shifted to Nagaon Civil Hospital. We took the deceased to Nagaon Civil Hospital on the night of the incident itself. Just after starting off his treatment there, the deceased passed away. Then we brought the dead body to Dokmoka police station and from there to our house. The police then took the dead body to Difu for post-mortem examination. Thereafter, I lodged the Ejahar with the police station. Exhibit 1 is the Ejahar and 1 is my signature. I witnessed the accused injuring the deceased by striking him with a bamboo lathi, and as I assume that he died as a result of that injury. This is his examination in chief, my lord.
Makes a different version, slightly.
Makes a difference, contradictory to PW2, my lord. Now cross-examination, my lord. Though I cannot see the distant
What
object.
is contradiction, Mr.
My
Ernst?
lord.
What is the expression of contradictory statement?
Because, my lord,
Slightly
he says
different.
that the
Different,
No, see, there is a difference. You have used the expression contradictory.
my
You can use the expression different.
different version,
Contradiction has to be something which is in conflict.
my lord.
There is no conflict. PW2 did not even say something about his presence. He is something, it's a different version, you can say.
My
different version.
different version, my lord. Because hitting part PW2 is totally silent.
Somebody
my lord.
PW2 has said that I did not see him hitting. Then he says, I saw him hitting.
My
This can be a
Both
contradiction.
cannot stand together.
My lord.
Yes.
Then, my lord, though I cannot see the distant objects clearly, yet on the day of occurrence, I could see the accused assaulting the deceased as I was nearby. On the day of occurrence, I arrived home at about 6:30 p.m. and it was around 7 p.m. when I had my dinner after cooking the same. There was no electricity supply in my village at that time. At the time of incident, there was little darkness at the place of occurrence. I did not see if the deceased consumed liquor sometimes. I am not aware if there was any dispute between the deceased and the accused. It is not a fact that I did not see the incident. The police took the bamboo lathi with which the accused had assaulted the deceased.
Yes.
Now PW4 again, my lord, he seems to be hearsay, my lord. Page 15, my lord. I know the informant as well as the accused.
Yes.
I also knew deceased. I do not remember the date of incident, but it took place at the time of Holi, 3 years ago. On the day of occurrence, I heard sound of coming of an ambulance to the house of deceased during the night time. Thereafter, I could know that a police vehicle also came there. Then I went to house of deceased to see what had happened. When I went to the house of deceased, many villagers had gathered there. At the place of occurrence, I heard the villagers saying that the accused had assaulted the deceased with a lathi. Later, I heard that this deceased had died in the hospital. So he appears to be, my lord, in cross, my lord. My house and that of deceased are adjacent to each other. Prior to arrival of the ambulance at the house of deceased, I did not hear any commotion there. I do not know if there was any quarrel between the deceased and the accused. PW5, my lord. He also, my lord, yes, my lord. I know the informant as well as the accused. I also knew the deceased. The incident took place in the year 2015. At the time of incident, I was at my home. The distance between my house and that of complainant is about 1 kilometer. The incident.
Yes.
The incident took place at about 7:30 p.m. After the incident, I heard from the villagers that accused Sikoram Gwala had assaulted his father-in-law, Sar Singh Gaur, on the head with a bamboo lathi. I also heard that thereafter the deceased was taken to Dokmoka hospital. On the following day of the incident, the deceased died at Dokmoka Hospital. Cross part of my lord. I do not know if there was any quarrel between the deceased and the accused, but I know that both of them consumed liquor. Now, my lord, PW6, my lord, page 18. He is Dilip Sahu, my lord.
PW?
6, my lord,
Six.
page 18, my lord. Dilip Sahu. I know the informant as well as the accused. I also knew the deceased. The incident took place in the year 2015. At the time of incident, I was at Dokmoka. Some person from the neighborhood of the accused informed me about the death of the deceased. I immediately went to the place of occurrence. When I arrived at the place of occurrence, informant Zoru Gore, the accused and the accused person's mother-in-law Beni Gore, informed me that around 6:30 p.m. the deceased told his son-in-law Chikoram, that he is accused, to collect firewood. Then the accused said that the deceased always asked him to do so with type of errands. As the deceased told the accused that he would give him a hand, the accused brought firewood, and as soon as he kept the firewood under the trunk raised for climbing Daffin Lima beans, 2 or 3 chicks died. As the firewood landed on them, the deceased became angry and said that though he had promised to give him a hand, why he killed the chicks? And after saying so, the deceased entered his house, took a khonti, came out and attempted to assault the accused. Then the accused assaulted the deceased on the head with a piece of bamboo, whereupon the deceased fell down on the ground. The villagers also stated in the same manner about the incident. Coming to the place of occurrence, I saw the deceased smeared with blood and the accused being beaten by villagers. I rescued the accused from the public and made a phone call to the police station. Now, this is contradictory to what PwC has said. He said that he was in a latrine, my lord. He fled away and kept him inside in a latrine, my lord. Now, this PwC says, I saw the deceased smeared with blood and accused being beaten by villagers. I rescued the accused from public and made a phone call to the police station. The police immediately came to the place of occurrence and took the deceased to Dokmoka Hospital. Since the deceased had sustained grievous injury, the doctor advised that the deceased should be shifted to Nagaon. However, the deceased died on the way to Nagaon Hospital. We handed over the accused to the police. Police seized a piece of bamboo from the place of occurrence, and I put my signature as a witness. Exhibit 2 is the seizure list, and 2-1 is my signature therein. Jiten Sahu, another witness of the incident, had already died. Basically, he is also, my lord, possibly hearsay, my lord, heard from 2-1, my lord, the wife of the deceased. Now, cross-examination, my lord. The accused and the deceased used to consume liquor daily. I heard that on the day of incident also, they had consumed liquor. I do not know if the deceased had any ailment. At the time of incident, the age of the deceased was more than 60 years. Whatever I have stated in the court today, I had heard the same from the villagers. I have not seen the seized lathi in the court today. The lathi with which the accused has assaulted the deceased at the place of occurrence was shown to us and by the police, possibly, my lord. It is not a fact that the deceased died as a result of assault being made by the accused. It is not a fact that the accused showed the lathi with which he had. Well,
Only that.
some wrong in the suggestion, possibly, my lord.
It seems.
Some wrong, my lord.
Anyway.
Did not, my lord, possibly left out. It is not a fact that the deceased died as a result of assault being made by the accused, my lord.
Anyway.
It is not a fact that the deceased accused showed the lathi with which he had assaulted the deceased. There were about 150 people present at the place of occurrence when we arrived here, but I do not remember as to who they were. My lord, PW7, my lord. He is also, my lord, hearsay. I know the informant as well as the accused. The incident took place at about 4 years ago. Around 9 p.m. on the day of occurrence, I heard from villagers that someone had killed Sir Singh Gaur. On receipt of information about it, I went to the place of occurrence and saw police personnel there. Thereafter, the police took the dead body to a hospital in a vehicle. I learned from the people present at the place of occurrence that accused Sikoram Gwala had previously injured his father-in-law, Sir Singh Gaur, by assaulting him with a bamboo lathi on his head. Later, I heard that the deceased died while he was undergoing treatment. No cross-examination, my lord. I heard from the villagers that the accused had assaulted the deceased. The accused and I are co-villagers. I know the accused and the deceased consume liquor often. PW8, my lord, page 22, happens to be the doctor, my lord, who conducted the postmortem. Page 23, my lord. On 6/3/15, I was attached at Bhogeshwari Fukononi Civil Hospital, Nagaon as medical and health officer. On that day, I conducted postmortem of the deceased Sir Singh Gaur, brought by so-and-so, Bijoy Gaur and others in reference to BPCHPP GD entry number 59 dated 6/3/15 and found the followings. External appearance, a body of a male person in stout condition with mouth and eyes closed. Rigor mortis was present. Blood stain was present in the left ear. Detailed description, my lord. A lacerated injury measuring 2 into 1 into 1 cm in the left parietal area of skull. Fracture of left parietal bone. Membrane was congested and torn underlying the fractured parietal bone. Brain matter under the fractured bone was lacerated and there was an intercranial hemorrhage. Liver, spleen, kidney, urinary bladder, and organs of generation, external and internal, were healthy. Abdominal organs were also healthy. The injuries noted were antemortem in nature. Approximate time since date at postmortem examination was between 18 to 36 hours. Exhibit 3 is postmortem report, and accordingly 3.1 and 3.2 are my signatures. Is the signature of Joint Director Health Services. Now the opinion, my lord. In my opinion, the cause of death was shock and intracranial hemorrhage due to head injuries sustained. In cross, he says, my lord, injuries can be sustained falling on the hard substance. Now PW9, my lord, page 24. He did the preliminary investigation, my lord. Bijon Kumar Singho. On 5/3/15, I was working as an ASI at Dokmoka police station around 8:40 p.m. That day, a person named Dilip Sahu from Telibosti informed the officer in charge Joyanto Kumar Singha over phone that one person named Sikoram Gwala alias Bui had assaulted his father-in-law Sar Singh Gaur with a bamboo lathi, and when the former Sikoram tried to flee, the villagers apprehended him. After getting this information, entry number 85 was made in GD and the OC instructed me to proceed to the place of occurrence, taking along a battalion party to carry out preliminary investigation into the matter. Accordingly, I proceeded to the place of occurrence, and after reaching there, I saw Sar Singh Gaur lying injured in his courtyard. Meanwhile, the villagers informed 108 ambulance services, and an ambulance had already arrived at the place of occurrence before our arrival there. Thereafter, Sar Singh Gaur was sent to Dokmoka Primary Health Center for treatment, and the accused Sikoram Goala was taken into my custody from that of the public. After that, I inspected the place of occurrence and drew a sketch map of the place of occurrence. Exhibit 4 is the sketch map and Exhibit 4.1 is my signature therein. I recorded the statement of the persons whom I found at the place of occurrence. When the bamboo lathi with which the accused has assaulted the deceased was showed to me, I seized the same in presence of witnesses. I also recorded the statement of witnesses who had put their signatures in the seizure list. Exhibit 2 is the seizure list and 2.2 is my signature therein. Thereafter, I went to the hospital, taking along the accused and the lathi, and got the medical examination of the accused done. Coming to the hospital, I learned that Sar Singh Gore's head injury was of grievous nature, and so the doctors there advised to shift him to Nagaon, and accordingly I brought him to Nagaon in the night itself. Thereafter, I returned to the police station, taking along the accused and the seized lathi. After completing the preliminary investigation, I handed over the miscellaneous case diary to officer in charge of the PS. I learned that Sar Singh died in the hospital at Nagaon around 1 a.m. on 6th of March. On 6/3/2015, a person, Zoru Gore by name, lodged an Ejahar with the police station. Upon receipt of the Ejahar, the OC of PS registered case being Dokmoka PS case number so and so, and entrusted SI Kolpojit Sharma with the charge of investigation of the case. Exhibit 1 is the Ejahar. Exhibit 1-2 is the signature of OC Jayanto Kumar Singha, which I have recognized. Now, my lord, cross-examination, my lord. The OC instructed me to carry out preliminary investigation through a GD entry. I am not aware if the extract copy of the GD entry is attached to the case diary or not. I have not seen the seized lathi in the court today. The fingerprint of the accused was taken. My succeeding investigating officer will know whether the fingerprint was sent to FSL or not. PW9, my lord, page 26. Here is the IO after registration of the case, my lord. On 6/3/15, I was posted at Dokmoka police station as second officer. On that day, one series Zoru Gore lodged an Ejahar before Dokmoka police station. After registering the Ejahar, Jayanto Kumar Singha, officer in charge Dokmoka police station, directed me to take up the investigation on the case. On the same day, I went to PO along with my staff and recorded the statement of the complainant and the witnesses in the PO. The victim, Sar Singh Gore, was already sent to Dokmoka hospital by villagers before my arriving at PO. I went back to the Thana. ASI Bijon Kumar Singha already took the accused to the police custody by Dokmoka PS case number, PS GD entry number so and so, and I examined the accused at Thana and find sufficient materials against him, and I arrested him. After completion of the investigation, I forwarded the accused Sikoram Goala to Honorable Court. The victim was sent to Nagaon Civil Hospital for better treatment from Dokmoka Hospital, but the victim was expired on the night of 6/3/2015 at Nagaon. I collected the PM report. After completion of investigation, I have found sufficient materials against the accused Sikoram Gola alias Bui, and hence I have filed a charge sheet against the accused Sikoram Goala Bui under section so and so. Exhibit 5 is the charge sheet and 5.1 is my signature. In cross, he said that seized material was not sent to FSL. Amar Singh Gwala Melo, next PW Melo. I do not know the complainant Zoru Gore and accused Sikoram Gwala. On 6/3/15, I was posted as in charge at Bhugeshwari Fukononi Civil Hospital, Noga. On that day, 7:30 a.m., Superintendent Bhugeshwari Fukononi Civil informed me that one Sar Singh Gore was expired at Bhugeshwari Fukononi Civil Hospital in reference to so-and-so GD entry number dated 6/3/2015. Accordingly, I conducted an inquest of the dead body of Sar Singh Gore at about 9 AM, Sri Joru Gaur identified the dead body. The dead body was a male person aged about approximately 61 years. Approximate the date of time and date was 6:15 at 1:25 AM. I conduct the inquest in presence of witnesses, namely so and so, Ram Singh, Joru Gaur, Ram Singh Gaur, and Vijay Gaur. Exhibit 6 is the inquest report, and Exhibit 6(1) is my signature. This is the, my lord, evidence, my lord, adduced by the prosecution side.
Inquest was conducted where? In the hospital?
Hospital, my lord.
Not at the, because he passed away at the.
My dear, my
No, also.
past event.
Okay.
My lord, possibly, my lord, in my humble understanding, the evidence of 2 and 3 are the most important, my lord. So far as the case is
Eyewitness.
concerned, my lord. Now, my lord, if we go by the ratio laid down from time to time, my lord, including Buddha Mura, my lord, passed by our Honorable High Court, my lord, if there is 2 set of witnesses, my lord, one contradicting the version of the other one, my lord, then, my lord, and if the court is not in a position to hold which one is believable, my lord, then possibly, my lord, the benefit will accrue to the accused person, my lord. My first limb of argument would be that, my lord. And secondly, my lord, PW2, my lord, she has not been declared by hostile by the prosecution, my lord. I do not know what is her 161 statement, my lord. If she is not declared hostile, my lord, her evidence becomes binding upon the evidence prosecution side, my lord.
Okay.
And then, my lord, the benefit possibly goes on behalf of the accused person.
But
My-
PW2 is also what?
So, my lord, in view of the contradictory version of the witnesses, my lord, a non-examination wife of the deceased, my lord, because PW6 has stated that he heard from Benny Gore, my lord, who happens to be the wife of the deceased. Coupled with the fact that, my lord, the seized lathi was never sent for FSL examination, my lord. Prosecution failed to prove that, my lord, the incident occurred as per version of PW2, my lord. And the injury, my lord, as per the postmortem doctor who conducted PM, my lord, he said that injury can happen due to fall also, my lord. And possibly that tallies the version given by PW2, my lord. Because if he has dashed in the betel nut tree, my lord, and subdural, my
It
lord,
was quite severe.
my lord,
Going by the medical
Milo.
evidence,
Milo.
it was quite severe because
Milo.
there was a intracranial
Milo.
hemorrhage or something.
My lord. But, my lord, the hemorrhage means, my lord, in my humble understanding, my clotting of blood, my lord. Clotting of blood, my lord, and due to the pressure, my lord, the possibly man dies. Here, my
Yes.
lord, if your lordship examines the PM report, my lord, the amount of blood clotted, my lord, there is no mention, my lord. And, my lord, I have gone through one judgment wherein it has said,
Have you, let us see the PM report.
my lord. Postmortem report, my lord, with 71, my lord.
71.
My lord. It starts from page 71, my lord. Page 73, my lord. Serial number 3, brain and spinal cord, my lord. Intracranial hemorrhage, lacerated underlying line fracture bone, my lord. Then, my lord, 72 also lacerated injury of 2x1x1 cm left in the parietal area. One stitch present fracture of left parietal bone.
Yes.
Well, the parietal bone is possibly behind the brain. I can.
Yes, what is your
My-
literature?
So if the disease is pushed, my lord, as stated by, with all respect, my lord, PW2. My lord, this injury possibly can happen, my lord.
Parrot.
My
this part.
My lord, the second count would be, my lord, even if, my lord, it is assumed, my lord, if we assume that he has hit it, my lord, because of the, my lord, clotting of blood, non-mention of the amount of clotting of blood in the post-mortem report, my lord, possibly it would not amount to commission of offense under section 302, my lord. May I place one judgment, my lord, for lordship's consideration, my lord? This is, my lord, with all respect, my lord, 2018-16 SCC 475, my lord. Lordship will kindly directly come to page 64, my lord. Para 64. Page 497.
64.
My lord. Para 64, page 497, my lord. In this case, my lord, fist blows were exchanged, my lord, in the brain, my lord. And lordship will find the injury, nature of the injury in para 64, my lord. The 64, my lord, page 497, my lord.
Yes.
The injury on the head of Gurnam Singh, as already noticed, is an abrasion head measuring 0.75 cm into 0.5 cm over the left temporal region, my lord. This is the injury in our case 2x1x1 cm, my lord. Because of the hard substance, possibly it is 2x1x1. Now, lordship will kindly turn to para 76, my lord. Page with all respect 500, my lord. Exactly 500. Para 76 is
76.
My lord, is 500.
Yeah.
My lord has found it, my lord. May I read, my lord? PW1 is also the author of a textbook, Forensic Medicine and Toxicology. In the 6th edition of his book, he has stated as follows: on most occasions, bleeding is slight, but fatal compression of the brain by a large subdural hemorrhage can occur within a few hours. It has been suggested that about 100 to 150 ml is usually the minimum associated with fatalities. Fatality is frequently associated with some concomitant brain injury. If there is no primary brain damage, the mortality from the subdural hemorrhage is usually related to the victim age, neurological status, and delay from the time of trauma to the surgical evacuation of the hematoma. 77, my lord. It can be noticed from the above statement, subdural hemorrhage by itself does not cause death, but it is the compression of the brain caused by the large subdural hemorrhage which causes the death. About 100 to 150 ml of hemorrhage is usually the minimum associated with the fatalities, my lord. In our case, my lord, possibly, my lord, as pointed it out in the PM report, my lord, nor in the evidence of the conducting doctor, my lord, there is no amount, my lord, regarding that quantity of the blood, my lord. 78, my lord. We shall assess the evidence on the record in the instant case in the light of the above, my lord. The statement made in exhibit and evidence of that head injury itself could be sufficient to cause the death in the ordinary course of nature are mere ipsi dixit. Neither any specific details regarding the volume of the subdural hemorrhages are available on record, nor any medical opinion that the subdural hemorrhage caused the compression of the brain that caused the death of Gurnam Singh. There is no evidence of any concomitant brain injury. The postmortem report and the evidence of PW are silent in this regard. The pathologist's report is clear about the absence of any pathology in the brain. Such being the evidence on record, the conclusion of the High Court that Gurnam Singh's death is caused by subdural hemorrhages but not cardiac arrest in our opinion is based on any evidence on record and is a pure conjecture. We therefore find it difficult to sustain the conviction of the first accused and set aside the same, because to find a man guilty of culpable homicide, the basic fact required to establish is that the accused caused the death. But as noticed above, the medical evidence is absolutely uncertain regarding the cause of death of Gurnam Singh. So in this case, my lord, it was converted to 323, my lord. Because fees blows were extended. Next paragraph, my lord. 79, the only fact established on evidence is that A1 gave a single fist blow on the head of the deceased Gurnam Singh. No weapon was used, nor was any past enmity between the accused and the deceased. It all started with the dispute regarding right of the way, resulting in a brawl between them, a very common sight in this country.
Yes.
That is my submission. If it is, my lord, relied upon that there is contradictory version of PW's, my lord, then benefit must go. And
Now, what about, how do you support your second submission that PW2 not being declared hostile?
My lord,
The prosecution is obliged to.
my lord, I have a judgment, my lord.
Please to us.
I can place it, my lord. That is Rajaram, my lord. 2005, my lord. This judgment has been followed in other judgments also, my lord. Para 9, my lord. Lordship may kindly go through. May I read, my lord? But the testimony of PWA, Dr. Sukhdev Singh, who is another neighbor, cannot easily be surmounted by the prosecution. He has testified in very clear terms that he saw PW5 making the deceased believe that unless he puts the blame on the appellant and his parents, she should have to face the consequences like prosecution proceedings. It did not occur to the public prosecutor in the trial court to seek permission of the court to her to PW to declare PW8 as a hostile witness for reasons only known to him. Now, as it is the evidence of PW, it is binding on the prosecution.
She is the wife of the accused.
Minor.
Is the
She is the wife of the accused.
and daughter of the deceased.
Minor. And wife of the deceased, my lord, though her name surfaces in evidence of PW6, my lord, she was not examined, my lord. That is my humble self.
So for my lord, my learned friend argued on 2 points, my lord. First, he argued on contradiction. In that respect, my lord, I would like to point out that my lord, the statement
Mr.
of
Das, have your seat?
PW2, my lord. The humble submission, my lord, that is not contradiction. Second, that the victim was assaulted by the accused, that is there. To be a to eligible statement, to eligible for a contradiction, my lord, that should shake the core factum of the statement, my lord, case, my lord. Here, the core issue is the assault. The assault is there. And one thing, my lord, we have to
No, actually, if I may just there's an important distinction actually, whether if this is true that he pushed him, the victim,
well,
he fell across and hit a tree and injured.
I'm coming to that. Here, one point we have to keep in mind, my lord. PW2 is the wife of the accused. Natural
Yes.
consequences that matter. Obviously, she will try to safeguard.
Mr. Kaushik, that is not available to you.
Yes.
She is a PW.
PW, but the
You on your own volition has chosen her to be a PW.
yes,
You have
hostile.
not declared hostile.
That's the thing.
At the appellate stage, you bring in the concept of relation. Yes, that's a probable thing.
Yes.
We also think of any human, but on your own volition, you chose the wife to be a witness for the prosecution.
yes. Here also, even going by the PW2,
Yes.
couple PW3 also. As I said, my lord, PW2, that is not a contradiction. The assault part is there, my lord. Even if going by her deposition, my lord, he was pushed. He was pushed and he hit the betel nut tree and succumbed to injuries, my lord. And my lord, PW8, the medical officer's statement coupled with the postmortem report, the injury. The injury, my lord, kindly peruse once again, page 71. 72, my lord. Lacerated injury so and so in the left parietal area once it is present, fracture of the left parietal bone. To break a skull, my lord, basically parietal bone, that's a part of skull, my lord. The great amount of force is needed. Just pushing a person would not break the skull.
Yeah, unlikely, but if he falls badly, and that too in a drunken state,
But
then some injuries
here,
might be.
no, from nowhere it has been shown that man, he fell from above. Even if he fell down naturally from standing position.
Yes.
And it is not that money he fell on a concrete slab or something like that. That fracture, initially he hit the betel nut tree, then he fell down. Even going by the PW2 state. And that shows how hard he was pushed. I somewhere read, my lord, to break his skull, my lord. minimum force is needed 2,300 Newton. And 100, my lord, 10, 100 Newton is 10 kg of force. Here around more than 200 kg force is needed to break a skull. So my lord, even going by the PW2 state,
200 kgs may not be correct. Correct. Can you have the literature?
my
To
lord,
break a skull, you need 200 kilos.
1 Newton perhaps, my lord, 10 Newton is 1 kg.
That much momentum.
Momentum.
So how much is required?
2,300. Somewhere I read by the this.
It might vary also a little bit.
It might vary depending upon the age of the person also.
Mr. Das, can
Might
you check with this version just for the sake of discussion deliberation?
My lord, I'll try, my lord.
And it depends also the age of the person, the health condition of the person also. Here, apparently the person is 60 years old. Still, to break a bone of a skull, great amount of force is needed. Just pushing a person, and my lord, here, from witnesses version, it came out that well, both the persons were Duncan condition. And to that effect, my lord, Duncan man cannot push a person.
But you see, what questions did you put to the PW2 in her cross-examination?
My lord,
This was not even your foundation.
my lord.
Suppose PW2 in her deposition, she had given a version which may not be absolutely as per the prosecution case.
Yes.
You did not declare her with hostile, number one. Number two, even in the cross-examination, see the cross-examination,
All mostly about drinking.
Mostly about drinking, not about assault. Mostly about drinking.
What I was trying to say actually that the different versions of PW2 and PW3 poses a bit of a problem in the sense that if the version of PW2 is true, suppose that push, then he falls and then injures,
Yes.
and PW3 as hit with a stick, a bamboo, and he injures the skull, then he dies thereafter subsequently. If the version of 2 suppose is accepted, then it may not even be homicide. But if the version of 3 is accepted, then it could be, it may not be 302, but it could be still be homicide. So these two versions, this is the problem.
Even in PW2 statement also, as I said, my lord, the assault part in both the statement, assault part is wrong. Only difference is one said by Lucky, one said. In this PW8 statement and the report, my lord.
has assault been defined? You're using the expression assault. Has it been defined? What is the meaning of assault?
Criminal
Assault is, my lord, defined in IPC, my lord.
criminal
Which
force.
one?
351 possibly, my lord.
Let us see. What does it say? What is the difference between assault and criminal force?
Force is 349.
Criminal force 350 and
Criminal force 350.
it's come to 351.
351.
The legal definition is slightly different.
Different, my lord.
Layman's definition is
That is what, please read. Whoever makes
Means
any gesture,
or any preparation intending or knowing it to likely that such gesture preparation will cause any person present to apprehend that who knows or who makes that gesture or preparation is about to use criminal force to that person is said to commit.
see, there is no even contact, there is no question of physical contact even.
Yeah.
My lord. Even if I saw the fist also, it will.
No, it will be assault.
My lord. criminal force is 350, my lord.
Yes.
Whoever intentionally uses force to any person without that person's consent in order to the committing of any offense or intending by the use of such force to cause or knowing it likely that by the use of such force he will cause injury, fear or annoyance to any person to whom the force is used is said to use criminal force to that other, my lord.
Yeah.
The hearsay witnesses, though they are all hearsay. So, but all of them have stated about hearing about assault by
Yes,
Lathi
Lathi.
and not falling,
Not by fall.
falling from being pushed.
Yes. Humble submission and that injury, my lord, that cannot be just pushing, my lord.
PW 9, can we come to PW 9, the second page? The police officer states about being shown the bamboo lathi. But there's nothing, he omits to say shown to me by whom. He does not say. By villagers or whatever. No? That's not shown. It cannot be taken as a disclosure.
Another point is that, my lord, conduct of the accused after the incident line, he hide himself in a villager's toilet, my lord. That is also really wrong. That's an evidence.
But again, my lord, PW 6 is versa is different regarding that hiding part.
We'll come to it.
My-
Have a seat. We'll hear you in a rejoinder.
My-
Have a seat. Let him complete.
6 only said we rescued the accused from public. He didn't say from where. He said, "Man, we rescued I rescued the accused from the public."
Is there any medical report of the accused?
That is not available.
Not there. In the records,
Record I'll have to see.
please check the records.
After arrest, he was sent for medical man. There, in the form, there is no injury, man.
Hmm?
No injury. What you want to say?
This flag the page.
I marked it. Mark it. So his conduct is kind of can be taken into account. Fleeing from the place. That has come out with the deposition of PW3. Requirement of non-sending of this lathi to a TSL minor. When there is a direct evidence by the IPSS minor, recovery of performing is also not. Here, PW2 and 3, they are direct IPSS.
No, but if you are talking about foolproof investigation, then it is necessary. His fingerprint, Lathi's fingerprint, if they match,
But
nails.
otherwise, the
Done.
full, but it's not necessary if there are direct evidence. In my humble submission minute, PW2, 3, and PW9, along with the post-mortem report, the injuries sustained by the victim simply clears that my lord, there was assault, which was sufficient for cause death. Even if you go by the PW2 statement.
And
also,
again, you're again using the wrong expression, assault.
A person's expression. That's how we understand.
regarding that might not force how much.
What about the what about the submission supported by the citation of Rajaram? That in view of the different versions of PW two and PW three, not three, was it?
Three.
Three. And PW two not being declared as a style, the version is required to be considered.
But here, PW2 in my humble submission, suppose the prosecution case. It's not, this is not contradiction.
PW three.
Sorry, two.
Let us again see PW two. Where is the sketch map?
It's 75.
75.
70.
two version judgment you placed, Buddha Mura.
My lord,
Buddha Mura.
my lord,
Of High Court.
my lord.
My humble submission, my lord, that PW2 statement and that PW2 statement is not, my lord, that difference, it's not contradiction and that is not material to the core issue.
Mm.
Core issue is, my lord, this person killed, initially they had a fight and he killed the person.
Mr. PP, Mr. Kaushik,
My lord,
let us again examine what PW3 has said.
my lord.
You are depending on the PW3 mainly,
Right.
isn't it? The eyewitness.
Two also,
Two does not specifically state regarding the
use of that.
use of the lathi. So you vis-a-vis the nature of the injuries, you say that the use of a lathi is more possible, likelihood of use of lathi. Kindly read again the PW3 at page 12.
Yes, my lord. I know the informant as well as.
And let us read.
I know
After the third line. As soon as I was eating, fifth line. After my arrival at home, my daughter-in-law called me to have a milk. Please take 75, page 75 side by side.
75. My lord.
So this Hilmisia Gaur is his daughter-in-law, nothing to do with the present incident. Okay.
My lord.
As soon as I started eating, my younger brother, Sursing Gaur, called me. If you see, Sursing Gaur is at A, that is the place of occurring, the
Yes.
house of the deceased.
Yes.
And B is the house of the present PW3.
Leave.
Okay?
My lord.
Just as I finished my meal, my so-and-so,
My lord.
after finishing my meal, I went outside and saw the accused hitting on the wall of his house, which is situated near my house with a big lathi.
My
See,
own
if
house.
own house.
Own
This house is at F.
My lord.
It is not the house adjacent.
Other side of the road.
There is an electric post, there is a road on this side. When his elder brother was calling him, instead of going to elder brother's house, we do not know from what is the distance from this sketch map, but nonetheless, F is at a distance. Please see F. He sees the accused hitting his own house.
And it is
The
on one
walls.
side of the road. PW.
You see, there are another way. From B to A, there is a small road
My lord.
which goes to A. There is a space in between. There is a road, and there is the house of the accused.
Accused.
What was the time? It was 6:30 p.m.
My lord.
It was in March 6:30 p.m. So it was in the evening. May not be absolutely dark, but it has become the evening,
Right.
dusk. But nonetheless, he observed that the accused was hitting the wall of his own house.
My lord.
We do not know how he saw and how he came to his house and said, do not do this. Then the accused goes to the house of A
Victim.
and he starts hitting the wall of the house of the accused. Accused came out and at
No,
that
my lord,
moment,
victim's house.
victim's house.
Victim.
The deceased came out, then the deceased was hit on the head. That is the version of PW3,
Brother.
brother of the
Brother.
deceased.
In my humble submission from this case, my lord, although this distance are not put, my lord, but this is a PW road. These are basically.
No, the PW road is not in between B and A, B and F.
My lord, BNF.
No, it's not between. So there is a lot of space.
Yes, my lord. There are.
There is a lot of space.
My lord.
There are other small roads. There are electricity posts.
My lord.
B and A, you can say almost to be adjacent because B himself says that A had called me and while I was having my meal and I went to, but he did not go to A's house.
Fine.
He came to F,
Because he was hitting his
the
own-
wall of his own house.
In my humble submission from this picture, my lord, I am getting the thing that, my lord, this is their entrance, their compound, my lord, from in front there is a road, other side. These electric poles are generally those roadside poles, right?
See, the Telebasti PWD road is the proper main road.
Properly.
There are other lanes also. One lane you go to the electric post, the other one goes to the house of the deceased. The same lane goes to the house of the PW3 also.
Video as it made an incident occurred in PO. That comes.
Caesar witness regarding the lathi is not there. No? IO had said that
PW3 said, no?
There are two Caesar witness.
two Caesar.
There is
Caesar
one
witness.
Caesar witness.
Lathi.
PW3 also said, man.
No, there are two Caesar witness.
No, one was not examined, my lord. The Caesar list was
Caesar
signed by
witness.
two, my lord.
Rathi was
presence of
seized.
witnesses.
PW3 says Rathi was seized
That was
in his cross-examination.
Yeah.
And one more.
PW6, my lord.
PW6, yes, Caesar witness, PW6 at page 1890.
Three is not a Caesar.
To add on, my lord, may I submit, my lord, to add on this, what?
Where is the Caesar list?
Caesar list, lordship
Exhibit
will
two.
At
find
page
it
69.
69.
69.
Piece of bamboo.
Where is the signature?
My lord, serial number 2, my name and particulars of Caesar witness. Ayodhya Sahu, then Dilip Sahu, my lord. Page 69 itself, my lord.
Yes. No, there are signatures.
Their signatures, my lord.
Ayodhya is a witness. Dilip is also a witness.
Dilip Sahu, PW6, my lord.
And Ayodhya?
Ayodhya is not examined because possibly PW6
7.
Ayodhya is there.
7.
Seven.
But through him, this Caesar list was not true.
This is on page 20.
PW6. He has stated about the Caesar list.
My lord.
Ayodhya did not say anything about Caesar.
My lord.
Caesar 69. What was it? Caesar 69. Caesar 69. And this is exhibit what?
My lord, exhibit 2.
69.
Origin to सब कुछ साइंस जरा खोज होगा.
Or
The PP, what have you done the Caesar? There is no witness, there is no signature of the Caesar witness. I thought that maybe while transcripting, typing out, signatures were missed. It's not there.
no signature.
No signature. It was accused. And this is the Caesar officer. No signatures here. Rightly in the third copy also, next thing, there's no signature. That's why we compare. Dilip is what? Number?
Six, my lord.
If say I put my signature as witness in exhibit 2.
What is this?
2-1 is my signature therein. Where is 2-1?
Right.
No? 2-1. Oh. It's there. See what they have done. What they have done is that in the form itself, name and particulars of the Caesar witnesses, they said that that is one of the
No,
signatures.
This is written by the police.
Probably IO has written it.
It's written by the police.
No, but no, that is in vernacular.
No,
And the handwritings are not the same.
no.
Son of, maybe their signatures were taken because Dilip says that 2-1 is my signature.
Right.
In that manner, perhaps,
In
trustee.
that manner. Instead of putting in below, they put it
Yeah.
there.
But that is not the,
Properly, but
it is not
they have
the.
taken.
Just a minute, please.
Right.
I know. All of that. Yes.
Right.
Last matter, one thing matter regarding this assault by, sorry, madam, is PWT statement that has not been that question was not put by the defense in cross
Regarding PW?
getting using of lathi madam to PW3.
Yes. What do you want to?
That was not rebutted by the defense.
How do you rebut in a?
Cross, my lord, they have not put any question regarding that. Any suggestion?
PW3.
PW3.
I did not see. Now, there was a suggestion that he did not witness the incident. He said that he has denied, but suggestion foundation was laid. Because in the last line at page 13, he says that it is not a fact that I did not see the incident.
Use of lucky and these things, these are not good.
If you read the cross-examination again, kindly read.
Though I cannot see the then object clearly yet, on the day of the occurrence, I could see the accused assaulting the deceased. As I was nearby. On the day of the occurrence, I arrived home at about 6:30 p.m. and it was around 7 p.m. When I had my dinner after cooking the same, there was no electricity supply in my village at that time. At the time of incident, there was little darkness at the place of occurrence. I did not see if the deceased consumed liquor sometime. I am not aware if there was any dispute between the deceased and the accused. It was not fact that I did not see the incident. The police took the bamboo lathi which the accused had assaulted the deceased.
You might be correct in contending that there is no reason to disbelieve him. But his version and the version of another PW, namely the daughter, she may be the wife of the accused, but she is also the daughter of the deceased. But while if you do not declare a PW as hostile, our relationship will not come into much relevance. To give the tag of an interested witness, you have to develop that in your examination itself, either in the cross, declare hostile, whatever you do.
To that extent, my argument was that core issue, that the killing of that person, because there may be minor contradiction or relation.
No, this is not a minor contradiction. One forcing him and he dashing and he falling on a betel nut tree, getting injured, and the other hitting him with a bamboo stump. Those are completely different versions.
But there may be
Even though the medical injuries per se are more compatible with a hit by the stick per se. But again, which version? I mean, how did he sustain that injury? By falling, or that's the issue in this criminal?
Yes, in that case, there may be difference in degree of assault.
No, if you are exceeding to that, then the aspect of whether it be a 302 or whether it is under 299, those aspects will come in.
Right.
In all likelihood, is going to cause death. In all probability, is going to cause death.
And another thing, if died by falling, he has to be fail from going by the injury.
No, that is no. See, you cannot now decipher. You cannot dissect the materials before us. It is there. You could have done that in the stage of trial by cross-examining. Yes. Now we cannot bring in new things. Facts are there before us.
Right.
Either you accept this or do not accept this.
Right.
Whether that is a true or false, whether because it did not fall from any height,
right,
so that this version is not. That is your version.
Right.
It is not a version of some defense witness. Yes. That you can disregard that. Right. So for you, it's difficult to say that no, you believe on this.
Right.
For you, PW2 and PW3, there is no difference. They are at par.
In that case, even if died by pushing also, that has to be a very severe one. Normal course, because the
see, you have just submitted that to cause a fracture in the skull, huge force is required.
Yes.
Now these are two adult persons, not a child that has been thrown to a betel nut tree.
Right.
Maybe push may be very hard,
but they were intoxicated.
And there is also one
because the word is push, not stress.
There is also one line that the deceased was at the time of the occurrence. The deceased was so inebriated that he could not even stand. at the time of the incident, the accused was also in an inebriated state.
My submission was.
Or my brother has said that the version that he was hit by a bamboo appears to be more acceptable, but we cannot totally disregard
That is the
PW
issue,
too.
problem. Because,
And-
sorry.
Yeah. And as you, Mr. Das has pointed out, if two views are possible, the view which is beneficial to the towards the assumption of innocence, that view is normally is to be taken.
In that case, even if you take the PW2 version, it seems it is beneficial. Then also, the hitting part was there.
Not hitting, pushing,
Pushing with a force, because the
Pushing with
normal
a force.
was not.
As we had mentioned at the outset, that if that version is accepted, it may not even be homicide at all.
That's the now I have no develop.
He's been in jail since the judgment, right?
Smile.
4 years. Huh?
Smile.
Yes, fine. This is the list. Yes, anything else? Otherwise, we'd like to close this.
Smile.
Heard Sri N.J. Das, learned amicus curiae appearing for the appellant, also heard Sri R.R. Kaushik, learned edition PP. Hearing is concluded. Judgment is reversed.
Obliged.
Okay, we'll consider.
Smile. Obliged.
আৰু single bench আছে। Yes. Item number
20, I guess. Good. Wait,
Yes.
Your Lordship.
Yes.
Lordship, this is an appeal, my lord, against the judgment dated 12/1/2024, my lord, passed by landed special judge Morigaon.
Like
He under section, my lord, 8 and 12